Welcome to Loopholes and Lawsuits. I'm Jamie Schrabeck.
And I'm Mike Vo.
In today's episode, we're going to discuss the interpretations, and there are many of them, of what the change in the law for licensed manicurists in California means for you, whether you're a licensed manicurist or you're a salon owner, or perhaps you're some other kind of beauty licensee and wonders if the law applies to you.
Yes, we're going to dive deeper into this. I know that there's some confusion out there. We've seen some comments from viewers about how to apply the test interpretation of the labor code. So we're going to spend a little bit more time on that. But before we get going on today's conversation, I want to make sure that all of our viewers know the disclaimer that we always give as part of our show. So the information and advice provided today is not intended to be taken and should not be construed as legal advice. No attorney-client relationship is formed through any of the discussions on today's podcast. You must consult your own private attorney for issues that are specific to your situation. Further, all topics of discussion are based on the law in effect at the time of taping. Please make sure to check for later podcasts of loopholes and lawsuits for any changes in the law.
Mike, that being said, you're an attorney whose practice includes many salon owners as clients. I'm a licensed manicurist and a salon owner myself. Can we just review where we get our information and how we come to our interpretations when we have these discussions?
Sure. So, as an attorney, I rely upon the actual labor code, the black text law of what our legislator passes and is codified. I always go first to the labor code or whatever other code is at issue. Now, in this case, we're kind of guided in some ways by a bulletin that was posted by the Board of Barbering and Cosmetology and the Department of Labor. However, I will say that I kind of disagreed with the bulletin in terms of the choice of language. I do agree with what they're saying about the ABC test applying as of January 1st, 2025, but I disagree when they said the laws were slightly changing for manicurists versus estheticians or hairstylists.
Mike, when we're referencing the labor code, I think we need to clarify that the code becomes the code when a law is passed. And I think that's part of the confusion we're seeing is that we're talking about this issue, but some people are referring to it as AB5, others are referring to the labor code, others are referring to the labor board. There are many different ways that what we can loosely refer to as the labor board oversees the employment situation in our businesses.
Right. So in this particular occasion, we're talking about manicures and how does the law change come January 1st for them. It deals directly with the labor code. And the labor code here would be how that employment relationship is viewed from a standpoint of, are you getting paid? Are you getting paid minimum wage? Are you getting paid overtime? Are you getting meal breaks, rest breaks? There's a lot of other issues that come with whether you are an employee or an independent contractor, right? So the Department of Labor, when they're looking at the laws as it relates to manicurists, they have to look at Labor Code 2778 B2L, or come January 1st, they're going to be looking at the Labor Code 2775. That's really what we as attorneys, judges, administrative law judges, the Department of Labor, if there's a hearing, that's what we rely upon. The confusion maybe that we're hearing and seeing, like people refer to things as AB5. AB5 was the assembly bill that was introduced post the Dynamex case so that Sacramento and the legislator could codify it into law. So it is actually inaccurate to continue to refer to this as AB5. AB5, it doesn't exist anymore. In the standpoint, it's not enforceable law. It's the bill that was introduced and then it was voted on by our legislator and then subsequently codified into the labor code. So I want to be very careful for our viewers. If you're referring to AB5, that's not accurate. If you have questions for Jamie or myself, please refer to the labor codes because it's really going to help inform the both of us to better provide the education that the industry needs when we know where you, the viewer, are getting your information from.
Mike, even since AB 5 was codified into the labor code, there have been subsequent bills that have changed it. And that's another reason why, if we keep referring to AB 5, the fact, for example, that we did get an extension of our inoperative date wouldn't be reflected in AB 5, but it would be reflected in the labor code.
Absolutely. You're absolutely right. That's part of the labor code, not referenced in AB 5. Again, I urge everyone look at the labor code and make sure that the people you're talking to, if you're in a Facebook chat forum, if you're on going to live seminars or whatever it is, please ask them what section of the labor code are they referring to.
Let's get back to this bulletin. Do you have any concerns that it's being provided on behalf of the Department of Industrial Relations and the Board of Barbering and Cosmetology, but they cannot answer questions regarding labor laws?
Factually, that is correct. It is not within the jurisdiction of the Board of Cosmetology to interpret and enforce labor laws, right? That's just not within their purview. So I do agree with that statement. So maybe the Department of Labor was concerned, hey, we just publish this or post this under the Department of Labor. Most of the manicures may never see it. So my thought is that's the reason why there was this joint posting to make sure that the information got into the hands of licensed manicurists.
We know what the law is currently and how it should have been applied, and we know what changes are coming January 1. We just don't necessarily understand what all the consequences and implications are.
Under the correct interpretation and application of the labor code, you're either an employee or an independent contractor. Surprisingly, Jamie, I've done many, many speaking engagements where I just simply ask four questions off the top. How many of you are employees? How many of you are independent contractors? How many of you are W 2? How many of you are 1099? About 90% of the time, everyone's confused. And it's just the first four questions that I start off with. Everybody's confused. Like, I'm not sure what I am anymore now that you did that, Mike.
I think it's because we equate our employment status with a tax form, and literally those numbers are referencing a form.
Yeah, it's just a Form 1099, Form W-2, right? And I think we all have seen that in the year. You get a document from either your employer or the person that engaged your services. But for purposes of application in this case, you're either an employee or an independent contractor.
If you are an independent contractor, you are not an employee, so you do not have the protections of an employee.
Correct.
Just because your boss calls you an independent contractor does not make you one. That's pretty casual language.
Yeah, it's very casual, but it's also very true. I've seen cases in my own practice where a manicurist, a worker says, I'm an independent contractor. And then I said, why do you believe you're an independent contractor? And we'll go through all the criteria. I said, I don't think you're an independent contractor. I think you're an employee. Just because the boss or the hiring entity calls you an independent contractor, or there's a document that says you're an independent contractor, that does not necessarily mean you are, in fact, an independent contractor.
I'm so glad you mentioned the word document. I am getting lots of questions about, well, what if I just adjust my contract to read differently? What if my contract satisfies the Borello test? Can't I just keep going on the way that I am? They didn't mention documentation here, or if you have a contract that states you're an independent contractor.
Right. This bulletin didn't say that, but and I think that's where the part of the disservice is here. If we look at the actual labor code, again, I go back to the labor code, right? 2775 B1, which is the A factor, the A test of the ABC test. It says that the person is free from the control and direction of the hiring entity in connection with the performance of the work. Now, here's the important part, both under the contract for the performance of the work and in fact. The labor code actually does reference the contract. But as I shared, just because a document says that, that doesn't necessarily mean you are an independent contractor.
Side question, Mike, does there have to be a contract?
There does not. But I know through my own practice that many people like to have a document to make sure there's a clear understanding. But again, just because the document exists and it says independent contractor, I'm going to ask you, did you do this, 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 and this? And more times than not, the relationship between the manicurist and the hiring entity is more akin to an employee versus independent contractor.
And it states that an independent contractor must hold a local business license, set their own service rates and schedules, and be paid directly by the client. That language should seem very familiar to us.
Right. So that language you saw there is the current operative language under Labor Code 2778 B2L. which identifies 5 criteria for a person to be considered an independent contractor.
An employer may be subject to penalties for misclassifying a worker, which we know is the case regardless of the industry. If you're not classifying your people correctly, then you face all sorts of consequences from all different kinds of agencies.
Correct. If an employer does misclassify, a lot of penalties that go with it. And it's not just the penalties, it's actually the wage issues, the meal breaks, the rest breaks. I mean, I handle that on a daily basis as part of my law practice.
And the next paragraph is a standalone sentence, and it's the only thing that appears in bold in the entire statement. Beginning in January 2025, the rules for manicurists regarding independent contractors will slightly differ from those applied to other BBC licensees.
That part, that sentence that's bolded, I absolutely disagree with. Slightly differ, it is a huge shift because our California legislator has essentially taken away the manicurist's ability to be an independent contractor or a booth renter. You're either going to be, under my interpretation of the way the code is going to read, is that you're either an employee or you're an owner. There's no in between there.
Let's clarify for our audience, Mike, that when you say the word booth renter, we're only using that term because that's how the industry refers to it, but that the IRS does not recognize booth rental. They recognize independent contractors.
Right. And I think you're absolutely right. That's another source of confusion. I see it in my practice where the owner will issue a Form 1099 to a manicurist at year end. That is incorrect. That is just not the proper way of handling that relationship. The owner should issue a Form W-2 to the manicures at year end. So the only time the Form 1099 should come into play with manicures are for those who are booth renters. They will issue a Form 1099 at the end of the year for rental payments to the owner of the space.
Excellent.
The labor codes and the laws that apply to manicures will differ from other BBC licensees.
Correct. And that's taken up in the next sentence. Beginning January 1, 2025, the ABC test, and here it references the labor code. Labor code section 2775B1 will apply to manicurists.
Correct. That part should be bolded right there. So the ABC test follows that, and that's really what manicurists need to be aware of. Under the ABC test, there is a rebuttable presumption that all manicurists are going to be employees unless the hiring entity or the owner can prove A, B, and C. It is not A or B or C. It is in the conjunctive. All 3 factors must be met. Before we go into the ABC test, I think this is something that's going to help us clarify some confusion. I've seen some of our viewers, either our loopholes and lawsuits and YouTube's, discuss or question whether you and I interpret it wrong, the labor code, we're not relying upon good source information. I want to go back to the current law. The current law, as of November 25th, right, is 2778B2L. It identifies 5 factors to be independent. Interestingly, though, factor number 6, which is where the exemption expires. And now I'm going to quote again. This subparagraph shall become inoperative, comma, with respect to licensed manicurists, comma, on January 1, 2025. My interpretation of that statement is that the legislator said, look, there is no ability to be an independent contractor or to have the booth renter situation. And the reason why I say that is that in criteria number 5, if the individual is performing services at the location of the hiring entity, then the individual issues a Form 1099 to the salon or business owner from which they rent their business space. So what Sacramento is essentially saying, look, these 5 criteria that we currently rely upon for independent contractor status or booth renters does not apply. That to me is an express statement from Sacramento. You will not have the 1099 situation. You will not have the booth renter situation, right? It's an ABC, but ABC essentially you're going to be an employee unless there's something very compelling, which I've yet to see, that would take a manicure outside of the employee status.
Mike, when you're referencing Labor Code 2778 B2L, and believe me, I'm doing this just from memory at this point. Those are those additional requirements that were negotiated and put into the bill AB5 in order to get all BBC licensees the exemption from the ABC test.
Correct.
So in labor code, that's where they landed. Those are those 5 different criteria, and then the 6th thing that's mentioned is the part that takes away that exemption from manicurists. That's the thing that's expiring, and we see that the date there is listed as January 1st, 2025, because, as we mentioned previously, there was a subsequent bill that passed, AB 1561, which gave us a 3-year extension, and it's that extension of our ability that expires at the end of this year.
Correct. So when we're looking at the labor code, I'm just looking at the black letter law. It says it expires. You don't have the 1099. You don't have the booth renter. So it would be hard to argue that, hey, we still can have a 1099 booth renter situation. So where do you see that? Because my interpretation is that no, Sacramento said you're not going to have it. You're going to be an employee or essentially an owner. You're going to be one or the other at this point.
The statement from the Department of Industrial Relations includes the factors of the ABC test, and it does emphasize that all of the following have to be met, which, I'm glad for that because it does clarify what the ABC test is for people who were unfamiliar. But then it summarizes by saying, so for instance, if you are a licensed manicurist and provide manicure services at a salon, notice it doesn't specify what type of salon. You are an employee and must receive all the rights and protections of that employment status, including minimum wage, sick pay, meal and rest breaks, overtime pay, and workers' compensation insurance coverage.
Right. And I have to wonder if that paragraph where it does not specify the type of salon, was that in conjunction or with the blessings of the Board of Cosmetology? Because the board does not recognize a nail salon license, a hair salon license. It is an establishment license. So I have to believe that the board said, well, you can't just say nail salon. It is all salons, right? So when we read this and we were to rely upon this for guidance from the Department of Labor, if you are a licensed manicurist and you provide manicure service at a salon, you're an employee. That I think will make perfect sense, right? You're back to Labor Code 2775. There is a rebuttable presumption that you are an employee. And if the owner wants to say this person is not an employee, the owner must hit the ABC test.
The Labor Commissioner's Office has on its website a page titled Independent Contractor versus Employee. And we will definitely include that link in our show description for you to reference for yourself. It's presented as a Q&A. It answers questions like what is AB5? What's the ABC test? How does it apply? What are the consequences? It gives examples. Now, mind you, this is geared towards all industries, not just the beauty industry, but we are mentioned specifically because we know that we're one of the industries that was given a special exemption. What I find fascinating is it reviews the Borello test, and we've not really talked about Borello much today, and that's okay because we realize come January 1, it's not relevant to us, which I think is kind of a shock because up until now, we've always thought of AB5, and I use that term loosely, and Borello sort of coexisting. Beginning in January, it's the ABC test all the way.
Correct. It is only the ABC. So I've seen comments from viewers or questions from viewers about application of Borello. Please be aware, Borello does not apply come January 1st. And if anyone's telling you otherwise, ask them to cite their source. Don't take just our word for it. Jamie's word, my word. I know that we spend extensive amount of time reviewing this material, analyzing it, but I would encourage all of you, all of our viewers, to do their own homework, to do their own research, understand why the law is written the way it is and how it's going to apply to you. Because I would hate for, one day someone is sharing with you contrary information and you believe it, but you never ask that person, what is the source of their authority? That's the most important thing. At the end of the day, if you have a Department of Labor investigation or you have a lawsuit, and let's say you come to someone like me, an attorney, and I say, okay, so you had all these workers and you thought they were independent. That's because you saw it somewhere on Facebook or somewhere on YouTube. Can you cite to me where that individual obtained their information, that this would be a legitimate and legal application of someone being independent, right? If you say, well, I don't know, they just said they were. Okay, well, that's the problem. You have people that are sharing information with you. And while there was probably no ill intent, the bottom line is we as attorneys and, in the court system, we're looking at what is the source of the law and how do we interpret and apply that law.
We'll have time to review this more fully later, but I want to give our viewers a heads up. Are there penalties for misclassifying workers as independent contractors? And the answer is yes. In addition to penalties that may be assessed for wage violations associated with a worker being misclassified as an independent contractor, there are civil penalties for willful misclassification. Under Labor Code Section 226.8, which prohibits the willful misclassification of individuals as independent contractors, there are civil penalties of between $5,000 and $25,000 per violation. Willful misclassification is defined as voluntarily and knowingly misclassifying an employee as an independent contractor.
Right. There's a lot of penalties, no doubt about it. There's also back wage issues. So that's where I deal with a lot of my clients on owed back wages. And we go back 3, potentially 4 years if there's an unfair competition claim that's tacked on to any lawsuit. So we're looking at minimum wage, overtime, meal break, rest breaks, wage statements. It's cost prohibitive. And a lot of times my clients cannot pay the back wages plus the penalties, and they're forced into a very tough spot. The other thing you also want to be aware of also, there's now issues of unemployment, right? Should the worker have paid into the employment system? And the EDD is going to want their fair share too as well. So there's a lot of issues that come into play when you inadvertently misclassify. It's even worse when you intentionally misclassify.
There's a question about if there's a grace period. Once the Dynamex decision came down, we were essentially on notice that the ABC test was in effect. Then it became codified. It became part of the labor code when AB 5 passed. We knew there was an inoperative date. It got postponed. We were fortunate enough to have it be postponed. And the grace period essentially has been all of this time leading up to January 1st. But on January 1st, there is no grace period.
There is absolutely no grace period for application of the ABC test under Labor Code 2775. It's very clear under the exemption sunsetting or expiring that it says as of January 1, 2025, the ABC test will apply.
Mike, you mentioned being able to go back a number of years to determine whether there are additional issues or penalties that can be applied. So, just because the ABC test becomes the law for us as licensed manicurists in January, that doesn't mean that these agencies can't look back to things dating back to 2020, correct?
So the statute it goes back 3 years for owed wages and potentially 4 years, like I said, if there's a claim for unfair business competition. So, for all of our viewers who are owners, just because you today or January 1st decide, hey, you know what, I'm going to reclassify my workers to employees, that does not absolve you of potential back wages that are owed to the workers. So, please keep in mind, just because you now make that change, it does not absolve you of back wages. What I would recommend though that you start now, because every day that you continue to misclassify somebody, you have that exposure. I would love to have someone higher up with the DRR come and talk to us to get an understanding of how they interpret the law. Remember, the DIR does not pass the law; they enforce the law. But in order to enforce the law, you have to figure out, well, how do I interpret the law? So I would love to hear how they interpret the law and maybe challenge them on some of their assumptions or basis for interpretation. And then once I understand that, I say, okay, now how are you going to enforce the law? What methodology are you going to apply?
I would love that as well. Thank you so much, Mike, for this discussion. I think it was what we needed to hear, particularly now as there continues to be a lot of misinformation and confusion. I hope we've gone a ways in clarifying what a law is, what the code is, how those two merge, and how they should guide our practices going forward. And if you enjoyed this podcast or if you disagree with it, by all means, you certainly can. Please share and subscribe so that we can bring more content to you.
Great. Thank you, everyone.
Thank you.